How you going, people? Karen retrial, day 17. This guy's an ATF agent. He went to the funeral with a couple of Albert, who were two cops involved in this. Not really involved. It was at their house, and they were drinking together. And the mysterious Jeep that keeps coming up that was parked, it wasn't parked, what time it left, etc. It's his Jeep. He's the driver of the Jeep with the plow. And he's testifying about that. Nothing critical yet. Okay, so he's testifying on how he knew the defendant and Karen. He knew them both. He considered them both friends. He had O'Keefe's phone number, and they mainly texted. Again, nothing really riveting or what I would consider relevant. It's basically a lot of foundation stuff. Oh, this is interesting. He saw Karen walk into this establishment, and she had a glass with a drink from the other establishment. So now we're going to say that she's stealing glasses, which isn't the end of the world, but this may be a setup for the glass that was found on the rear of the car and around the body is the same glass from this place. If that's the case, this is pretty good testimony, because he's now tying the glass to her that she walked into this bar with a glass from another bar. And then if that glass ends up being the same glass from the other bar that she took, we know that she was carrying a glass, or that was the glass that was found on. So this could be critical information.
Just ask one further question in regard to that. And what makes you say that?
Well, she walked in with it and took it out of her coat, but it wasn't consistent with the type of glasses that the waterfall had.
And so let me.
Okay, so basically his questioning is, where was he in the house? Did he ever go in any other rooms, upstairs, downstairs? No. This guy is a pretty good witness. He's not getting over specific. He's kind of being general. His answers are flowing. This is going to tie in that every person in the house testified that they never went to the basement. There was never no fight. They don't remember O'Keefe ever being in the house. So this, big conspiracy that he was in the house, everybody knew it and everybody's lying. I mean, that's a big lie to keep up. Nobody's going to text. Nobody's going to call. Nobody's going to get blood. Nobody's going to have second feet. Everybody's going to risk their careers. This guy was lieutenant in a fire department. Now he's an ATF agent. All these other guys are retired Boston cop. The wives raise good children. They're good moms. They're waiting up for their kids to get home. And somehow, on this night, they decide to kill a fellow cop, lay his body in the front yard, and get this great story together. And nobody's made a mistake. And nobody's turned on him. Nobody's cut a deal. And nobody said, I'm not being involved in risking prison to cover up some murder. Yeah, that's, the odds of that happening is slim to none, and Slim left town. But anyway. Okay, so the prosecution just asked him a bunch of questions. After he left with his Jeep, he went back to the police department to move his surveillance vehicle and his private vehicle so they could plow the parking lot. And during the questioning, the prosecution asks, how do you get in there? And do you have a key? And do you have to be buzzed? And yes. And he goes, are you aware that those records are kept when you come in? He goes, I'm not aware. I've never seen it. But he goes, I've heard they were tracked. So I'm anticipating they're going to pin this guy down on what time he left. He was 5 minutes away from the house. So we're going to know when that Jeep left the house because he arrived at the PD, according to the key card, at this time. So I'm assuming that's going to come in later. This was interesting. He got a phone call at 6:30 a.m. from the chief of police and Albert at the house he was at the night before where the murder occurred. Where the setup occurred. And he said he was about to say what he was told on the phone, and the defense objected. They don't want to let him say what he was told on the phone, which is kind of odd. So now they're kind of getting into, what did you do after the phone call? And he goes, I immediately got dressed and started heading back to the house. For some reason, the defense did not want him to say what he was told. I don't know why. They objected again to what was discussed on the phone. As a juror, you got to wonder, why doesn't the defense want us to know what they talked about? It's kind of odd.
Mr. O'Keefe, any impact did that have on?
Well,
And did you know why they were distraught?
because John had been found on the lawn.
And is that why you had gone to the house?
Yes.
And when you received that information or were informed of that, or what, if any, impact did that have on?
Well,
Objection again. They do not want to know what he was told because obviously it blows a hole in their conspiracy theory. So they're trying to not let that in. Wow. Okay, so he just testified that how did he respond when he found out about the dead body? And he's like, it did make sense to him because he knows Karen and John O'Keefe never showed up to the house. So he was confused why his body was there, which corroborates that he never went in the house and nobody beat him up and it blows the conspiracy theory. I'm assuming the phone call was something like, what do you mean O'Keefe was there? He never even showed up. Why would his body, how did his body get? Those questions blow their conspiracy, and that's why they don't want it in, is my guess. I don't know. Oh, this is interesting. When he provided all his texts from his phone to the police voluntarily, there was 56 pages of texts between him and Karen Reed. And he already testified that he sent her a flirting text that night. So that's probably where the defense is going to kind of say there was a love triangle. But this also gives him specific firsthand knowledge of the relationship between those two, either good, bad, or indifferent. And I'm sure that will come out here shortly. So he's getting emotional because he was playing video games with a nephew. And I don't know if something happened to the nephew or if this just makes him closer to O'Keefe, but for some reason he's a little emotional here.
With his nephew while
we were playing video games together.
And so the text, if I could.
So this is the second time the nephew and niece has come up where his voice is cracked. So I'm not sure where this is going or why, but we'll see. Okay, so it sounds like this witness they just broke for lunch. They're getting into, they met, one of the texts was, it was all Karen's fault. And I'm not sure how we're going to get into that. I'm sure he's going to get into the text between him and Karen, since there seems to be more text between the ATF agent and Karen than with O'Keefe. But anyway, this was a witness that I missed on day 16, so I wanted to add this in. This is the girl that got into an argument and testified about Karen's jealousy and outrage when they were at a party together.
Was stumbling into the lobby.
And did you go over to him at that point?
I did. I went up to him and I gave him a hug.
And what happened then?
I pulled back. He was glassy-eyed, looking above me. We never made eye contact. He was looking above me. It looked like he was looking for someone. I asked him, where are you going? Assuming that he would be coming to the pool bar to meet us. He kept looking around and he indicated that he was going that way and pointed toward a bank of rooms to our right. And I said, well, you should go that way. And I stepped back and I guided him toward the area that he was going.
Now, as far as the bank of rooms to the right, you indicated that you were familiar or aware of where Mr. O'Keefe was and where the children were. Is that correct?
I know they were on the first floor. I'm not 100% positive as to where exactly their rooms were.
And if you know, did you know whether or not that Mr. O'Keefe was staying in the same room as Patrick and Kaylee at that point?
I didn't know if they were staying in the same room or not, no.
So you point him in that direction, and what happened?
So I pointed in that direction. He walked off. I continued out to the pool bar when I heard very loudly his name screamed across the lobby, very angrily, and it made me stop in my tracks.
And when you stopped in your tracks, what happened?
I started to turn around to come back in. So once you go out to the pool bar, you kind of go around a corner and you go out of view. So I turned around to go back in. As I'm going back in, I hear someone yell, "Who the fuck was that?" And as I come around the corner, I see Mr. O'Keefe walking toward a woman. And he said, excuse me. He said, calm down, that's Laura's little sister.
And what happened then?
When I came back around the corner, I said, after Mr. O'Keefe said, calm down, that's Laura's little sister, I said, hi, nice to meet you. That's when Miss Reed's head snapped up, and she very loudly told me to go fuck myself across the lobby. And I said, yeah, fuck you too, and walked away.
Okay, so now they had to read a jury instruction on her that, look, her conduct, and of course the prosecution's always just going to come back and go, you weren't at the house on the 29th, you don't know what happened, right? To kind of discount this. But this is just laying a foundation of the jealousy and how this woman, usually when she's drinking, can get loud and out of control. And I think they're painting a pretty good picture. And I'm assuming this ATF agent is going to further paint that picture But we'll see. They broke for lunch. So it appears that she texted him, got his number, not from her boyfriend, and she's texting him without her boyfriend knowing about it. Now, I don't know if this guy ends up telling John that he was texting his girlfriend behind his back, but we'll see. But it sounds like she's kind of hitting on him, and it sounds like he's being a little receptive. So we'll see where this goes. Oh, shit. So he's leaving his buddy's house, the dead guy. He's in the shower. His girlfriend walks him out and kisses him. Wow, this girl's got, she's being portrayed as a hothead, and now she's cheating on her guy, which is why probably she's so jealous, because the ones that's so jealous is usually the one doing the cheating.
How did she kiss you?
Not like a friend.
Lip to lip, is that fair to say?
Yes.
Like a romantic kiss?
That's the way I interpreted it.
And were you still inside the house at the time that this occurred, or were you outside the house, if you know?
Not sure if we had just got to the outside or not. It might have. I'm not sure if it was close proximity to leaving.
And what was your reaction to that?
I was taken back.
Was that something that you were expecting?
No.
And about how long was it between when the defendant kissed you and when you left?
Oh, almost immediately.
So he just said these texts happened between January 12th and he died on January 29th. Here's motive. That's a little iffy, but we'll see where it goes. So out of all these pages, he's having him read all these texts into the record, which is kind of interesting, I guess.
Hillside for sure. When were you interested? Defendant responded, I don't know, you're just my type. I responded, you think you can handle me? I thought you were happy, question mark. Defendant responded, how do you know if I'm happy? I said, I just assumed. Defendant responded, are you hard to handle? I may have put a question mark. Then I said, what do you like about me? Defendant responded, I just feel like you're from my neighborhood. I said, yes, yeah, ditto. Defendant responded, and I think you're hot.
And if I could direct your attention to the next page, page 30. If I could ask you to read from that, sir.
I'm in the blue bubbles again. You really think that? I have always thought that about you. Defendant responded, what? I responded that you're hot, smart, witty, but I didn't think you were interested. Defendant responded, witty? I responded, yeah, meaning quick with a response. Tell me why you got my number and reached out to me. Defendant responded, just thought we were the same / from the same neighborhood. I responded, are you afraid to say what's on your mind? What's in your mind? And then I said, on. Defendant responded, no, didn't I? No, didn't I? Question mark.
And sir, if I could turn your attention, to the next page, 31, and ask you to read from that.
I'm glad I'm in the blue bubble again. I'm glad I stopped by. I should have come earlier. Do you really live in Mansfield? Defendant responded, yeah. I was basically begging you. I responded, you don't have to beg me. I meant to say beg. Defendant responded, huh? I said, I will give you what you want. How are you texting right now? And I said, leaving me hanging. Defendant responded, no. I typed kids and then kinda. Defendant responded, how am I texting? And I began to say, is everyone asleep?
Now, as far as the communication from the defendant indicating, yeah, I was basically begging you, what did you take that to mean?
That you wanted me to come over?
And if I could turn your attention to the next page, 32. If I could ask you to read from that page as well.
So it starts off with the defendant saying, I just wide awake on my phone. Yes, they are. I said, I should have stayed, LOL. So now what? Question mark. Defendant said, yes, you should have. I responded, that would have been distracting. So now what? So no, what? And then I said, now. Defendant said, now what? Question mark. I responded, balls in your court. Defendant said, what do you want? I responded, loaded question. What do you want? Question mark. Defendant responded, I asked you, exclamation point.
Pretty much everybody knows where this is going. It'll be interesting to see if he ever told John before he died.
37, and ask you to read from that.
Defendant said, sorry, should I not have? I responded, I'm fine with it. Just don't know why you can't answer. Defendant said, you're mad at me? I said, OMG, no, not at all. You're being silly. Defendant said, I told you, exclamation point. I just think you're like me and I'm attracted to you. And then she said, a lot. I responded, feeling is mutual. I just never saw this coming. Defendant said, why? Question mark. I responded, because I just assumed you were happy with your situation. Defendant responded, I was, but things have deteriorated.
And if I could direct your attention.
So once again, we confirmed that she was upset that she was taking care of the kids and she wanted out of this relationship.
because I went from being solo to trying to give attention to kids who aren't mine, and I never wanted kids. I responded, I thought you were in this happy relationship. Defendant responded, everyone is happy at the hillside.
If I could direct your attention to the next page.
So they end up hooking up as she comes to his house, and they had a weird briefing to where nothing happened. This guy keeps saying he's venting to her, and John was a friend, and he didn't want to be used, but he was kind of communicating with her behind this guy's back, and he didn't tell him. So this guy doesn't look good. Now, the defense may end up trying to paint this guy as you had a motive to kill John because that way you could have his girlfriend. I don't think that's true at all. From these text messages and from this guy's description of her, I think he figured out she was a whack job. But here's part of his closing testimony when they hooked up.
Kind of wasn't an interrogation. It was a face-to-face version of trying to suss out and vet, like, what is this all about? Again, I mean, I'm not proud of these text messages. It is what it is. I'll take responsibility for them. But, John was a friend at the same time, and I certainly wasn't. If they were at the end of the relationship, they were at the end of the relationship. But I wasn't going to have somebody utilize me and weaponize me against somebody that I liked. And it was just a weird experience. It was. I don't even think either one of us finished a drink. It was, like I said, it was this type of like, what is this all about? And then she left. I think I might have asked her to text me when she got in, so I knew she got home.
Now, that evening or at any other point, in your friendship or your relationship, whatever, however you want to term it, was there any other sort of intimate contact beyond what you described occurring as she walked you out that night you were over at Mr. O'Keefe's house for the patrons?
Are you asking if she ever kissed me again?
I'm asking if there was any kissing, any sexual relationship, anything at all between yourself and the defendant.
Absolutely not. In referring to my residence when she stopped by, I was very uncomfortable, and it was just an uncomfortable situation. Just a weird vibe. That's the best I can describe it.
And lastly, sir, lastly as it applies to this, turning your attention to the last page, number 118. Start reading from, where it says Sunday, January 23rd, 9:40 p.m.
23rd at 9:40 p.m. Defendant texted me, phone works, and then an emoji with arrows going like both ways. And I responded, thought you were all set, question mark. Defendant said, with talking, question mark? No. I said, are you sure? And she didn't respond, and I believe I said, that was it for that, the 23rd, I'm sorry.
So then the next date that any text communication was sent between the two of you would have been Friday, 11:32 p.m., is that correct?
That's correct. That would have been when we were at the waterfall.
And again, what does the text say there?
Well.
That's from you to her, is that correct?
Yes.
And then the next text communication is the following day, or Saturday, the 29th at 11:54 a.m., is that correct?
Yes.
And who was speaking in that communication, and what is it?
That is the defendant, and the defendant said, John died.
And did you respond to that at all?
No.
And did you have any other communication with Ms. Reed following receiving that text message on January 29th?
No, I have not.
Thank you, sir. Ms. Gilman, you can take it.
Wow. So I'm assuming they're pretty much done, and now the defense is going to get on this guy. Okay, so the defense is automatically trying to discredit him out the front, implying that since he has an attorney, he must be guilty and have something to hide. If this cop was smart, he'd be like, the defense says your client has 3 attorneys sitting here. I only came with 1. I'm not sure why that matters. This defense attorney is going to eat him up on this attorney thing.
Mr. Higgins?
Who did I travel to the courthouse with?
Who did you meet here?
An attorney, my attorney.
Is there a reason that you felt compelled to bring an attorney with you for your testimony as a witness in a homicide investigation?
Objection, Your Honor.
Sustained.
Trial, I should say.
Sustained.
You brought your attorney with you who's sitting right behind you, correct?
That is not my attorney.
Oh, I'm sorry, I thought you were his attorney. My mistake. Where's your attorney?
I don't know. He might be in the courthouse.
Is he in the building?
I don't know where he physically is right now.
Okay, without telling me anything that you said to your attorney, did you meet with him this morning before your testimony?
Yes.
Did you meet with him during the break? Again, don't tell me what you talked about, but did you meet with him during the break when we took a break a few minutes ago?
Yes, I did.
Okay. And obviously the subject matter, again, without telling me any communication, the subject matter was your testimony here today, correct?
No.
He didn't want that answer. Watch how he moves over this and ignores that because it's not what he was expecting.
How many conversations have you had with Mr. Lally about your testimony or your proposed testimony in anticipation of you testifying today?
1.
When was that?
That was on Monday.
How long was that conversation?
I would say under an hour and a half.
In person or over the phone?
In person.
Where was that conversation?
That was at the DA's office.
Who else was there?
My attorney, victim witness advocate, I believe her name is Kristen Collins, ADA McLaughlin, ADA Lally, and Lieutenant Brian Tully from the Mass State Police.
Anybody taking notes?
I did not. I don't know if anybody was taking them.
So this is what you call a fishing expedition. He asked all these questions and he wants to find out things that he didn't know. So let's see here.
When was that?
That was on Monday.
How long was that conversation?
I would say under an hour and a half
In person or over the phone?
in person.
Where was that conversation?
That was at the DA's office.
Who else was there?
My attorney, victim witness advocate, I believe her name is Kristen Collins, ADA McLaughlin, ADA Lally, and Lieutenant Brian Tully from the Mass State Police.
Anybody taking notes?
I did not. I don't know if anybody was taking notes.
So the reason, and he's asked other witnesses when they met with the DA, was anybody taking notes? In discovery, you have to include all notes, which is why a lot of times they don't take notes, because if they take notes, then they have to give it up, and they know that. So there's a reason nobody takes notes, because they don't want to give it up on what they talk about. So what he's looking for is if he said, if I can get you to say somebody took notes and I didn't get it, then I can scream the prosecution is hiding. So this is what he's trying to find, little holes that he can throw up more smoke.
You were sitting there watching Lieutenant Tully. Did he take notes?
Not that I saw, no.
So you had an hour and a half long conversation with the prosecution team and a police officer witness, and you're telling me that you did not see anybody taking a single note down. Is that right?
That's correct. I did hand something to Lieutenant Tully, but he didn't take any notes in reference to what I handed him.
What'd you hand?
Uh-oh. If he handed him something, it's discoverable. He better hope that he gave a copy or whatever he gave, they got.
I handed him a piece of mail that I got at my residence.
Anything have to do with this case?
Oh, I believe so.
Was that turned over to Mr. Lally?
No, I turned it over to State Police.
You want to maybe approach for a second?
Yes.
So this is going to be like, oh, they're hiding. What did they give? We need to see what was this mail. If it has to do with the case, he's got to give it to us. This is an integral part of our defense. Oh, this is going to be good. Sidebar. So probably what happened at the sidebar was, Your Honor, we never got that. And then the DA is going to be like, I don't know what he's talking about. The state police never booked any evidence or told me about it. I'll have to find out. And when I find out, I'll discover it. Because discovery only happens if you do it. But because the state police is investigating this and they're part of the prosecution team, whatever they have, the defense is supposed to have. So even though the prosecutor didn't know about this letter or may not know that he gave it to him, he's still responsible to give it to the defense. So it's an issue. It's not a big issue. He'll turn it in. They'll say it was a mistake and we'll move on. Unless it was something that was really critical and would take weeks and involved a witness that was out of town and now they can't subpoena that witness, then it would be an issue. But I have no idea what's in a letter and I'm assuming we'll find out. Okay, so the defense is saying that these two guys that he knows, they got in a fight at a party. Big freaking deal. Cops are aggressive, egomaniacs. Sometimes they fight, they get aggressive, they don't like each other. That's not shocking. But this guy is making a big deal and trying to get it in. The prosecution's trying to keep it out. I don't know why they just wouldn't let it in. This trying to keep it out makes it more important to the jury than if you just let him answer. But here's the exchange.
Or Officer Hernandez.
Objection, Your Honor.
Knew,
Ask the question.
you knew Officer Hernandez before you ever knew Brian Albert.
Yes.
You knew him before you even knew Kevin.
Yes.
And you're aware that there was a physical altercation
Objection,
between
Your
Brian
Honor.
Albert and Eddie Hernandez that you're aware of, correct?
The objection sustained.
Are you aware that Brian Albert had gotten into a fist fight with Eddie Hernandez?
Objection.
Sustained.
Were you at a Christmas party when that happened?
Objection, Your Honor.
Sustained is to that form. You can be specific, though.
Have you ever been at an event with Brian Albert and Eddie Hernandez?
So, from all the objections and all the sustained, is there anybody that doesn't believe these guys were in a fist fight before and we're just playing legal mumbo jumbo? The jury knows, you know, I know, the attorney, everybody knows, but we're playing these legal games of objection and sustained.
And seen them fight?
Objection.
Christmas 5 years or so before 2022.
Okay, the objection sustained.
You do know that Brian Albert has a reputation for being a fighter.
Objection.
Sustained.
You were asked in a formal interview, do you recall, I want to make sure I'm clear about.
So, I don't know what's the big deal in keeping that out, but I think by keeping it out, it made it look more important than it is to me. Oh, this was interesting. Judge called him to sidebar for bringing that shit up. He's going to get his butt chewed. Listen to this.
You indicated in that formal interview that even Chief Berkowitz was
Objection.
quote, a little afraid of Brian Albert.
All right, so that is the objection sustained. That's stricken. I'll see you at sidebar.
That means he was told not to bring that shit up and he did it anyway. Guess what? You can't unring a bell. Defense attorneys know this. Prosecution know it. They ring the jail. The jury knows it. Everybody knows it. And she's going to run over there and say, don't do that again. I'll hold you contempt. I'll fine you. Blah, 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 blah. Whatever. He got it out. Now everybody knows the chief was scared of this guy and that he's violent. And now they want the jury to believe that the police department's out of control and that's why they killed this guy and everybody's lying. It's just smoke and mirrors BS. So this ATF guy has been around a while and he keeps asking the attorney, is that a question? Because the attorney likes to tell stories. And I've said that earlier. The defense likes to tell a story and then kind of make you think it's a question. And this guy has asked him 2 or 3 times, is that a question? So this attorney knows he's looking bad when he does that because then he has to rephrase the question and he kind of wants to be a smartass to this guy. And the judge says, well, that wasn't a question. That's pretty funny.
Well, it doesn't take that long to drink a beer, does it? If you're sort of thirsty and in a hurry.
Is that a question?
Everything I say up here is a question.
Okay.
Just presume
Well,
that.
all right. So
Well, that wasn't, so.
So let's question. Yes, Mr. Higgins, that was a question.
All right, let me put a question mark at the end of that.
Okay.
So your memory that Brian Albert had more drinks than you did when you had those 3 to 4.
So he knows he looks bad and now he's going to try and clean it up. But this attorney's a little weasel. I can't imagine the jury thinks he's a good, smart dude. They had a sidebar and I wanted to talk about if you're in courtroom demeanor. This is a person who's being accused of killing her boyfriend. She was drunk. She's already been demonstrated that she does things questionable, cheating, accuses somebody of doing something, then tries to buy it out of it. And this is how she acts in a courtroom. Kind of grinning, rolling her eyes. Now look, sitting in a courtroom all these days can get old and tiring. And even as a cop, sometimes I would do things that I'm like, oh crap, if that got caught on video, I'd probably look like I didn't care. But she's a suspect. And the way she's acting is this is a big joke, which is exactly what I think it is. This whole conspiracy thing is a big joke, but it's working and they think it's funny. Meanwhile, there's a dead guy that the person that killed him may walk. She's made googly eyes at this attorney several times.
Thank you. I was trying to figure out how we do that.
is that in reference to the key swipes? Yeah, I don't know.
So the attorney is probably trying not to act like this is funny and like we shouldn't be doing this, don't be joking, control yourself, but she doesn't have a clue. Okay, so this is interesting. The witness has an attorney. They had a couple sidebars, and now the judge is having the attorney stand next to the client while he's testifying. I don't like this because it implies that the witness needs protection because he did something wrong. So I don't like the way this looks. He's entitled to counsel before answering questions, and I don't know what the question is going to be, but we're going to find out.
Your client, or a couple of questions he's about to ask your client, doesn't make any sense to me that somebody has counsel and the counsel is not aware of a potential issue. So you'll hear the offer of proof. I'll let you speak to Mr. Higgins before this actually happens before the judge.
Could I just have him identify?
Yes, I was just going to ask you to identify yourself.
Sure, my name is William Connolly, spelled C-O-N-N-O-L-L-Y.
All right.
May I, Your Honor?
Yes.
The witness has indicated that he utilized federal resources for personal gain. The specifics of that testimony have been as follows. He indicated that he contacted Matt Kelch, a federal agent. He indicated that he utilized a federal facility. He called it an unsecure facility, but it's a federal facility notwithstanding, and that the two of them, he and Agent Kelch, utilized federal resources in the.
So it sounds like that the attorney may be thinking this is getting into criminal, and any statements he makes that he did this could be criminally used against him. He's a federal agent, and he's helping law enforcement with a case. And even though he's a witness, it's no different than him driving the ATF vehicle to go to a funeral of an officer that wasn't even ATF or he knew. So I think this is a nothing burger. I think his attorney's going to tell him to ask it and don't care, but we'll see what they do.
Form of some kind of a machine, as the witness indicated, for his own personal gain, so that he could, as a witness, in no official capacity, work in any official case, and in Matt Kelch's capacity as an individual rather than an agent, they both.
So he keeps making it seem like this guy was doing this for personal gain. First of all, he's not gaining anything. He's trying to aid law enforcement in an authorized official investigation. He committed no crime and he did nothing wrong.
Work together to download certain information from the witness's phone in anticipation of turning that highly selected, highly curated information over to law enforcement so that he could later ultimately destroy his phone, which this witness in fact did.
Okay, so it's not entirely, I disagree with you. I don't think it's reached that level. His testimony was that he went to a kiosk on the first floor where all local police departments can go. It's unrestricted. It's on the first floor. And we just got to the part about a machine in the kiosk when you mentioned an FBI resource. So what is your question? What questions do you intend to ask this witness now?
Whether he is aware that under 5 CFR 2635.702, it is a federal offense to use his public to use any public office for his own private gain or for the gain of persons or organizations with which you are associated personally.
This was not personal gain. He was aiding in an official investigation. I don't think this is personal gain. If they proved he used that to delete his phone and destroy evidence, well, then we have something else. But he just wants to throw up smoke.
In other words, an FBI agent or an ATF agent cannot use federal resources for personal gain. The fact that he contacted an ATF agent, the fact that he utilized a facility that is owned by the federal government, run by the federal government, paid for by taxpayer dollars, and the fact that he used a machine that is owned by the federal government to download certain information for his own personal gain, that personal gain being, these are the curated texts that I'm going to turn over to law enforcement, that's a federal offense.
All right, so those questions are going to be asked. I don't know that there's been an objection to them. I'm not sure I'm going to let them in, but I wanted to give you the opportunity to speak privately with your client in the back room there. Can you do it in short order? Or do you need
I
more time?
can do it in about 10 seconds.
Okay.
Sure.
All right.
If you feel the need.
So why don't you go back and talk to him? I'll stop bringing the jury.
Okay, so the reason why she's going to kick them out and go do that is because attorney-client privilege only applies with counsel in a private setting. If a third party is with you, you lose your attorney-client privilege. So attorney-client privilege is if I'm your attorney and me and you are in a room, anything we say is confidential and covered by attorney-client privilege. If you bring your wife in and I give you advice and she's in there, we lose our attorney-client. She becomes a witness and she can give that information. Therefore, you lose the attorney-client privilege. That's why this guy was going to give him something in 10 seconds saying, you didn't do anything wrong, answer the questions. I'm pretty sure that's what he's going to tell him. But she goes, no, go in a private room. Because, she doesn't want to violate their attorney-client privilege coverage if he tells them with other people present. I'm assuming that's what happened. Okay, the jury was out when this happened, which is good, and now they're bringing in the jury.
Mr. Higgins, you indicated that the phone was hooked up to some sort of machine at the FBI kiosk, correct?
Yes.
You're aware, sir, that under 5 CFR 2635.702, you may not use your public office for your own personal or private.
So the reason he's asking this in front of the jury is to imply that this guy's a criminal and breaking the law. His answer should be, I didn't break the law. I didn't violate that section. I was working in official capacity to assist another law enforcement agency in investigation. I don't know what his answer is going to be, but we'll see.
Private gain or for the gain of persons or organizations with which you are associated personally under pain of a federal offense, correct?
Objection.
No, Your Honor.
Are you aware that under 5 CFR 2634.704, it's a felony to quote...
Objection, Your Honor, as to reading.
Go ahead and finish the question.
For an employee, an employee has a duty to preserve and conserve government property and shall not use such property or allow its use for other than authorized purposes. Were you aware of that federal regulation?
That objection sustained.
Sir, notwithstanding those regulations, you utilized the services of Matt Kelch as a friend and a colleague, but utilizing federal resources to pull information off your phone, correct?
Objection.
Sustained as to that form.
In fact, you were successful in getting information off your phone, which is the text that you turn over to the Commonwealth, correct?
Objection.
In that form, you're almost there, Mr. Jackson. That form was improper.
The information that was ultimately pulled off your phone was the information that you selected and you and Matt Kelch worked together to get off your phone, correct?
Objection.
Is that correct?
No, Your Honor, if I could explain.
Sure.
He walked me through on how I could pull the text string with John O'Keefe and the defendant. He walked me through the process, how to use the machine.
And then you did that?
I did do that. That's
and
correct.
That's what you turned over to the police?
That's correct.
And any other information would still be on your phone ending in 5421, correct?
Well, that information stayed on my phone. I just took those strings off and provided them to the Mass State Police.
Right, so where's your phone?
I do not have that phone anymore.
You've destroyed that phone, haven't you?
No, I threw the phone away.
Well, that's destroying the phone, isn't it?
I had every right to do that.
I didn't ask you about your rights. I asked you what you did.
Objection.
Sustained.
You destroyed the phone by removing the SIM card. Correct?
Objection.
Sustained.
Did you do that? Did you pull the SIM card out?
Objection.
Did you pull the SIM card out of your phone?
Your Honor, to the best of my recollection, if I did take the SIM card out, I would when I threw it away, if I was going to take it out, I would break it or cut it. But I did not wipe the phone. I did not take anything else off it. But if I was going to throw the phone away, that's what I would have done.
Okay?
You know, as an ATF agent with electronic data experience, when you pull the SIM card out and break it, and then throw the phone away and the SIM card away, you don't need to wipe the phone.
Objection.
Sustained. Mr. Jackson, that's it.
Your Honor,
One more question.
I can do this in 30 seconds. I think. You were aware that that there was a court order.
No lawyer does anything in 30 seconds, except bill you for an hour.
That you not alter, delete, or destroy, or in any way manipulate your phone or the electronic data associated with it, correct?
Objection.
As to what date?
As of September 30th, 2022.
Objection.
Okay.
I don't believe that's what the court order was. I think
Your Honor,
it's
I made a quick offer of proof. That's exactly what it was that he was notified.
Were you aware of that? Was that your understanding?
What's the question exactly, Your Honor? I'm sorry.
Ask the question again.
Sure. Were you served with a copy of a notice on September 30th, 2022, that you not alter or destroy or manipulate anything on your phone on September 30th?
I was served an order. Yes, that's correct.
And isn't it true in another hearing, you explained that on September 29th, the day before you claimed you got that notice, you changed phone carriers and changed phone numbers
And I maintained the phone.
until you didn't, when you destroyed it a month later by pulling the SIM card out and throwing it away, correct?
objection.
Sustained.
Did you do that in October? Did you destroy that phone?
Objection.
Sustained.
Did you pull the SIM card out of your phone, Mr. Higgins?
Did you?
It's possible that I did. I believe that's how I've testified. Yes.
You testified
It's
that-
possible that if I took it out, that it was either cut or broken,
It's not just
So
possible.
that,
and that would have been after the date the order was already denied.
Mr. Higgins, I have one question left. One question. Did you, Mr. Lally already standing. I haven't even started.
have a seat, Mr. Lally. Go ahead. Last question, Mr. Jackson.
Quiet, please, quiet.
Mr. Higgins, very simply, and then we're done. Did you remove the SIM card for that phone, drive onto a military base, throw the SIM card in one dumpster and the phone in a different dumpster?
That is not correct.
Did you testify
That
that?
was your one question, Mr. Jackson. All right, folks, that's it for today. We received
Okay, so I'm not sure they made much. I'm sure he's going to be back the next time he testifies. And that was today's hearings. 40 minutes. I think this guy is pretty believable. I think he was probably going to cheat with this girl. I don't know if he was going to tell him. Did he get in this big conspiracy and hide evidence and got the chief and got all these people involved and was calling everybody in a 22-second phone call and clearing up and helped drag the body in the street? And come on, people. All right, defense throwing up smoke. If anything, I think prosecution made good points today, and Miss Innocent setup girl looks more guilty to me. We'll end it there.